When a landlord starts a holdover petition, he stops taking rent. Tenants find this extremely disconcerting for some reason. I suppose it's upsetting because it's a concrete symbol of the fact that the landlord just doesn't want you. And so tenants always ask, should I keep on sending the rent even if the landlord sends it back? No, you shouldn't. Why should we risk money orders getting lost in the mail? Just save it. What happens is that you'll be asked for the rent money once the holdover gets to court. Only the rent won't be called rent at that time. It will be called use and occupancy. Do yourself a favor and save the rent money. Don't spend it, because the failure to pay use and occupancy is the fastest shortcut to an eviction you've ever seen. Tenants always ask whether they should escrow the rent during a holdover or just other endless questions. Tenants' ability to obsess over this issue just knows no bounds. It's simple. If they're refusing the rent in a holdover, stop sending the rent and be ready to pay it when the time comes. In most holdovers, tenants are constantly told that if they lose, the judge may force you to pay the landlord's legal bills. In many cases, this is a real concern. If you have a lease, and if that lease has a legal fees provision, and if the landlord wins at trial, you will likely get a money judgment for the landlord's legal bills, which can be in the tens of thousands of dollars. So it's a risk, and it takes a qualified lawyer on your side to weigh that risk. The vast majority of housing cases are tried in front of a judge without a jury. That is because most leases have a jury waiver provision. Check your lease. Rent-controlled tenants and any occupant who never had a lease may have a chance at getting a jury, as long as they demand a jury when they file their answer. Even when you can get a jury, though, you still have to decide whether having a jury is the right strategic decision for you. Most housing court advocates will say that I presented too little information in this video, while a lot of novices will feel overwhelmed and feel that I presented too much. Whatever the case may be, I hope that this video will serve as a tool that you could use with your other resources in order to effectively fight your housing court case. See you in court.
You're going to become like 62 and you want to go into the spree program, but you also have a sibling that you would like to have the apartment, get the apartment later on. Is that
I live on the Upper West Side. I've got 2 children, a rent-stabilized apartment. I've been there for 35 years. I was wondering how hard it would be to get their names on the lease.
This new law that they passed is that the nephews cannot, or the aunts and so forth, cannot succeed, succession rights. He told me I have 30 days to get out.
Succession rights, one of the most important issues for the 2 million residents of rent-stabilized apartments in New York City. Here's how it works. Your mother's name is on the lease, she moves out of the state, and you continue to live there. Do you have the right to a lease in your name? What if you are the niece of the tenant? What if you are not married but just are in a committed relationship with the tenant? If the tenant dies, do you have succession rights? I have answered these questions for tenants live on the air for years. In this show, we take a look back at those phone calls and at one of the most hotly contested areas of housing law today.
Yes, hello. I have a question. I live on the Upper West Side. I've got 2 children, a rent-stabilized apartment. I've been there for 35 years. I was wondering how hard it would be to get their names on the lease.
So how long have your 18-year-old and your 19-year-old lived in the apartment?
I'd say about 2 months.
Okay, and so they would have to live there for 2 years prior to you moving out in order to get succession rights. But that wasn't your question. Your question was, how can I get my children on my rent-stabilized lease, where I've lived in the Upper West Side for 35 years? And the answer is that you cannot, because that's in a sense not the way it's done. If you have a lease tenant, that lease tenant has children, and those children live in the apartment. What it is those children are not considered co-tenants. they have every right to be in a rent-stabilized apartment. No one can throw them out or anything like that just because they're not on the lease. But they are not considered the lease tenants. But what do they get? They get, if you happen to die or move out, perhaps your kids are getting big now, so maybe they'll just throw you out. If in fact that happens, your children, your family members would have succession rights to the apartment if they meet certain criteria, which in a nutshell means they have to live in the apartment with you for 2 years prior to your passing away or moving out. Send the landlord a certified letter which states, I want to inform you, and please put this in the tenant file, of who lives in the apartment, and state the names of the people, their relationship to you, if any, and their ages. You put it in the letter as a way of making, putting it on the record who lives in the apartment, because if they lived in that apartment for 2 years, they get succession rights. If you go to manhattanfirm.com, and you click on housing information, and you go to rent stabilization and rent control, I have a fact sheet that explains your children's rights. That's right here under succession rights. So you go to my succession rights fact sheet, and it gives you the statutory basis of succession rights for rent stabilized apartments that I just explained. Also, this covers not just rent stabilized apartments, it covers rent controlled apartments. It covers not just people who are heterosexual and married. It covers people who are homosexual and are in long-term relationships. It covers not only children, but it covers, I think that it covers grandchildren. And it covers a lot of people who are in what the court might define the non-traditional family relationship. So it doesn't have to be blood relatives. It might be somebody who the two of you consider that you live as if you're husband and wife, or as if you're brother and sister, or father and son, or whatever.
Experience Filipino dance, martial arts, and legend from New York's famous nonprofit dance troupe, Kinding Sindao. Learn more at kindingSindao.org.
The reason for the breakup, who was the cause of the breakup, plays no part in the determination of equitable distribution or custody, for that matter, or child support. There is no punitive aspect to the determination made by the judge. See, the bottom line in most matrimonial actions, once you get over the emotional issues of the breakup and the difficulties with socially and the child custody and things like that, the bottom line is financial. It's very important, and it's beneficial to all clients to remain